Hello friends, in the series on the income tax cases, today we will discuss a very important issue on section 263 proceedings and section 271 subsection 1 clause C proceedings. The first issue before the Honorable Patna High Court in the present case was that whether the Principal Commissioner of Income Tax has a power to revise a order of penalty for dropping the penalty by the assessing officer. And the second issue was that if the assessing officer has not expressly recorded a satisfaction regarding the initiating the penalty proceedings in the assessment order, but from the reading of the assessment order it becomes discernible that the assessing officer wants to initiate the proceedings, then whether this will be sufficient for initiating the proceedings against the assessee. This issue has been taken up by Honorable Patna High Court in the case of Principal Commissioner of Income Tax versus R.A. Himmatsingka and Co, and this case is reported in 478 ITR at page number 456, and the date of the judgment is 27th February 2024. The present case relates to the assessment year 2004-5. The facts of the case are very interesting. The assessing officer has made some additions. The CIT appeal also upheld those additions, and when the matter was before the tribunal gave some partial relief for the additions to the assessee. For the matters for which the tribunal has not given the relief to the assessee, the assessing officer dropped penalties for those issues also by saying that there was no intention or attributable desire of the assessee in those omissions during the assessment proceedings. The Principal Commissioner of Income Tax initiated the revision proceedings under section 263 for dropping the penalty proceedings by saying that the order passed by the assessing officer for dropping the penalty was erroneous and prejudicial to the revenue. The assessee challenged this revision proceedings in the tribunal, and the tribunal noted the finding that there was no satisfaction of the assessing officer in the assessment order for initiating the penalty proceedings. So the revision is also bad in law. When the matter came to the Honorable Patna High Court, the court said that first of all, by following the judgment of the Honorable Supreme Court in the case of Mac Data Private Limited versus Commissioner of Income Tax, which is 2013 judgment and which is reported in 358 ITR at page number 593, the assessing officer is not obliged to record his satisfaction in a particular manner or even to reduce it in writing. The court said that if from the reading of the assessment order there appears that the assessing officer has recorded satisfaction, then it is more than sufficient. The court said that in the present case, if we read the assessment order, then there is a clear indication that the assessing officer has recorded its satisfaction for initiating the penalty on the assessee. So on this ground itself, the questioning of the penalty proceedings or the questioning of the revision proceedings by the tribunal is not justified, and hence the court was of the view that in the present case the Principal Commissioner of Income Tax was justified in initiating the revision proceedings against the assessee, and these revision proceedings that were regarding the dropping of the penalty by the assessing officer is justified. So from this case, two things emerge, that first of all, the revision proceedings are also possible for dropping the penalty proceedings by the assessing officer, and the second thing comes that if from the bare reading of the assessment order it is discernible that the assessing officer is going to initiate the penalty proceedings, whether it is for the furnishing of inaccurate particulars or for concealment of income, then it is more than sufficient. There is no need for the assessing officer to do that in a particular manner or to reduce it in writing expressly. At the end of this video, once again I am repeating the name of the case. The name of the case is Principal Commissioner of Income Tax versus R.A. Himmatsingka and Company, and this case is reported in 478 ITR at page number 456, and the date of the judgment is 27th February 2024. Thank you, friends.